Let's move on to agenda item 3. This is our Law and Licensing Committee report out. If you remember from last meeting, we began the report with the first action item. We had a couple of motions. This is and I apologize, Chair Carey, if you were going to tee this up, or would you like me to proceed? Okay. So I'm going to let us know where we were and then turn time over to Chair Carey to take it away for his committee. But if you remember, we began on R277-217, Educator Standards. There were some motions made. We ended with a motion that struck new language on line 138 and reinsert stricken language on lines 139 through 141. That passed 9-5. And that's where we currently are. So, Chair Carey, I recognize that there's nothing. I just took everything that you had to tee up. I apologize. I'm gonna turn your mic on. Anything else that we can get ready for?
No, we're still in the accepting motions or amendments, I should say, to the proposed rule.
Perfect. So I've got a couple lights on. I've got first we've got member Earl, and then we've got member Lear. But let me jump back to the underlying motion that is before us. And it is that the board approve R277-217, Educator Standards and LEA Reporting, Draft 2 as amended on second and final reading. That is the motion that is before us. Member Earl.
I'd like to make a substitute motion. I'd like to move draft 4.
There's a motion to move draft 4. Is there a second? Well, we went through this not too long ago. If we want to work off of draft 4, or are we just adopting draft 4? Okay, so the motion, apologies then, I just wanted clarity. The motion is that the board approve R277-217 draft 4. It's been seconded. Member Earl.
Yeah, so the two changes that were made last week are incorporated into draft 4. It has one modification. It's on line 162, and I can read through it for the public. It would be subject to educators' constitutional rights against self-incrimination. Let me just start with an educator shall. That's the beginning of that sentence that's up above, if that makes sense. Like, it's all these provisions, just so that this makes sense when I read it. An educator shall, subject to the educator's constitutional rights against self-incrimination, fully cooperate with criminal or civil law enforcement and LEA investigations involving a student or employee of the LEA's educator's LEA by responding truthfully and promptly to lawful inquiries by law enforcement, by providing relevant information within the educator's knowledge or possession, and complying with lawful subpoenas, warrants, or other compulsory processes. And that's the only change in that rule, but it does incorporate the two amendments that were made last week by this body.
Member Lear.
If I could I ask the maker of this draft 4 a question specific to this new provision? On line 146, just above where you're adding this information, if I can read what that says, parentheses 6, cooperate in providing all relevant information and evidence to the proper authority in the course of an investigation by a law enforcement agency or by the DCFS regarding potential criminal activity, except that an educator may decline to give evidence against himself or herself in an investigation if the evidence may tend to incriminate the educator, as that term is defined by the Fifth Amendment of the U.S. Constitution. Can you help me understand how these are significantly different and how both are necessary?
I mean, I think that's a fair question. I think there's provisions that that 10 adds to it, providing just that promptly responding to lawful inquiries by law enforcement, also complying with lawful subpoenas, warrants. It just gets a little bit more specific in that, the idea being that that they need to promptly do that. Up here, it does say cooperate. in providing relevant information. But I think we've seen cases even recently where individuals have said, well, we're not going to do that. So I think this adds a little bit more clarity. If we needed to combine the two in some way, capacity, that can be worked on. So
Can I have a follow-up, please?
Follow up, go ahead.
First of all, I don't believe we've seen cases where that has been shown objectively to be true. Secondly, I think it is confusing to keep adding pieces of the same provision over and over again. It's confusing to educators. It's confusing to the general public. I don't object to this parentheses 6 on line 146 that's been in place for a long time. Of course, I think educators should cooperate, but I think the information of lawful warrants and et cetera is covered by all relevant information and evidence to the proper authority in the course of an investigation. I don't think we need to belabor the legalese. So I don't object if the maker of this motion wants to work on combining these two and bring us something that is more streamlined. Even line 146 and plus is a little clunky. I don't object to that, but I don't think we should keep adding pieces of the same important conduct standard throughout a rule. We should be clear in one place and cover what we want to cover and not be overly legal, because I think it sounds insulting to those who are reading it. Doesn't sound clear. So that would be my suggestion. I'm not going to vote for the motion as it is because I think it's covered. But I would not object if the maker of this motion wants to try to combine the two artfully.
Got Member Carey?
I would just like to speak in favor of the motion. I think what it does is that it makes two necessary changes in that if we read lines 145 through 150, as I read that, it says, and I'm quoting, regarding potential criminal activity. This amendment makes clear that this would apply to investigations that involve criminal or civil law enforcement. And I think that's absolutely essential. The other thing that I think that it does is that as I read lines 145 through 150, I do not see a required obligation to cooperate with the investigation of an LEA. And the way I read that is that if an LEA is doing an investigation, civil or criminal, and it goes to a licensed educator and asks questions of that educator, under this particular provision, the educator has no duty to cooperate with the LEA investigation. I think that is detrimental to, or could be detrimental to the safe operation of our schools, and I think it potentially pits the educator and the LEA unnecessarily in an adversarial position, where the amendment would make clear that the duty to cooperate with an investigation extends to the LEA as well as to law enforcement. But I do think Board Member Lear brings up a good point about redundancy, and with the chair's permission, I would like to ask Director Rasmussen, in light of the should this amendment pass, would lines 145 through 150 be necessary, or would that be redundant? And if it's redundant, then perhaps that could be struck.
Ben, question on your feet. Sorry, I don't know if you had time. I don't know if this was, just your initial thoughts. And if more comes to light later on, please let us know. If we need to make changes, we can.
Ben Rasmussen, Director of Law and Professional Practices. The biggest difference as I see it is just the specific reference to DCFS, but I think that would be, that could be construed as civil law enforcement. So I think you could either strike 145 through 50 and specifically reference DCFS in the new language. I think that would work.
Okay, does that answer your question, Member Carey? Go ahead.
Yeah, that does. So if I understand Director Rasmussen through the chair, we could strike lines 145 through 150 as long as we added a provision into the amendment that specifically referenced DCFS. And thank you.
Thank you. I've got Member Davis, then Vice Chair Wood.
Is draft 4 draft 2 that the committee moved forward with only this change?
From the maker of the motion and that individual who worked on draft 2, I'm hearing yes.
It has the two.
Let me get Member Earl.
It has the two amendments from that were made last
Right.
week. So
It
it's
already passed?
yes.
That already
Yep.
passed,
But,
yes.
and that's all. So draft 2 as moved forward by the committee, the 2 amendments that we passed last week, and these 2 changes, and that's it?
This
Yes.
one change.
Or this one change,
Yeah,
sorry.
there's
Thank
no
you.
Just that
motion.
one section.
Thank you.
Vice Chair Wood.
May I ask the maker of the motion a question? Through you, Chair.
Please.
Okay. Can you help me understand how lines 166, 167 add to the language from 159, 160, be forthcoming with truthful, accurate, and complete information to an appropriate authority regarding known educator misconduct that could adversely impact the performance of a professional responsibility by another educator? I ask because it appears to me that that is very clear in the information has to go to the appropriate authority, where this is just relevant information within the educator's knowledge or possession. It just seems so broad as to what you're asking them or kind of compelling them to speak, as the above language is clear as to what language is required.
Well, it sits under 10, so it's not just an 11, right? So it's sitting underneath 10, which would be in cooperation with investigations that are taking place. So it is very relevant to that. It's not just, anything.
How are they different? Like, why are we adding additional language if it's already in there?
Can you tell me what line you were referring to?
Subsection 9. If I'm hearing correctly, as you're reading that, Member Earl, if I'm hearing correctly from Vice Chair Wood, the question is, subsection 9 is already covered, already covers or should be encompassing with all the others. And so, am I hearing that correctly? Even if it was put at the end, and so 9 and 10 switched, would 9, you know what I mean, be duplicative, or would the A or would the B and C be duplicative of the new 10?
Let me look down through it again.
Well, as you look at it, let's go to Member Carey.
Yeah, I had the same question, and as I reread it several times, this is the conclusion that I made, and that is that line 160 refers to known educator misconduct, where the amendment refers to the requirement to cooperate with an investigation. And I think an investigation by definition includes conduct that is known as well as suspected or purported. And so I think that this, again, puts us in the right direction of, I want educators to feel that they are protected. And because our rule requires it, they are, in a sense. There isn't this sense of, I'm sharing information that I would otherwise not, that I normally wouldn't, because now our rules require it. So it's not just information that you know, but you have a duty to cooperate with a civil, criminal, or LEA investigation. And that's the way I understood the difference. Thank you.
Okay, board members, we are back to our substitute motion, and that is that the board approve R277-217 draft 4. Now, as we prepare for a vote, here's what I'd like to do. We have, the majority of us are here, and so if you are sitting next to a blank seat, grab a microphone and slide it over. So we've got member Green will be, member Bollinger will hit the button. Member Boggett, or member Boggess, Brenton, member Carey's helping out. You've got member Reel, one of you, either Carol or Aaron, perfect. And then member Hall, and not everybody's with us. We're kind of having an in and out day, but we will, as we do a voice vote for those online, we'll keep an ear out. And who's got member Booths? Is that you, member Boggess? Or okay, perfect. I've got member Lear, member Davis, member or Vice Chair Wood, then member Boggess. So member Lear.
So I just want a clarification about this vote as it's set up, as it's proposed. So we'd leave in both provisions, both parentheses 6 and member Earl's new parentheses 10 that have very similar language and sort of talk all over the one talks over the top of the other. There's no effort or there's no desire to combine the two and clean it up. Is that what I'm hearing?
I have not heard of a motion yet, but you're welcome to put one
I
forth as well.
Just vote no. Thank you.
Okay. Well, guys, I'm just going off of lights here, and so now I'm back to member Davis. I've got member Wood, then member Boggess.
I thought Joe was going to do it. He thought Jenny was going to do it. She thought maybe I don't know. I'll do it. But someone might be able to do it better. I move that the board add DCFS before criminal on line 163 and strike lines 145 to 50. Thank you very much, Director Rasmussen.
So there's a motion before the board that the board add DCFS before criminal on line 163 and strike lines 145 through 150. It's been seconded. Back to you, member Davis.
I yield my time to the floor.
I love to hear it.
To the chair, maybe.
Yeah.
I've always wanted to say that in this room.
Yeah. Well, bucket list item. Member Boggess for a different one.
Well, if somebody else can, I'm still trying to comprehend this motion because it's not in context.
I know there's been discussion surrounding it. The feeling, if I'm capturing what I'm understanding from the board or from, excuse me, individuals on the board, is that subsection 6 was encompassed in subsection 10, except for the DCFS reference. And so for clarity, the DCFS reference will be included to subsection 10 and subsection 6 will be stricken.
I have no comment on this motion.
Okay, then let's get this ready for a vote. The motion is that the board add DCFS before criminal on line 163 and strike lines 145 through 150. Let's go ahead and vote. Voting is open. Member Green?
No.
Member Brenton?
No.
Member Booth?
Yes.
Member Hall?
Yes.
Member Reel? Okay, that passes. 11 in favor, 3 opposed. Those in opposition being member Lear, member Brenton, and member Green. Okay, this brings us to our underlying motion. And I can't see it. We'll go to it's to adopt draft 4 as amended. Member Bogus.
So we have multiple facets of this rule that are currently out of alignment with our legislative code. Would the will be that we postpone this to the next board meeting, or would you like me to make these amendments one at a time?
The motion that I see is that the board approve 217 draft 4 as amended.
So then I move that we postpone this until the next board meeting.
There's a motion to postpone until next board meeting. I'm assuming our October 3rd.
Yes.
Okay.
Second that.
There is a second? We did a motion to postpone. I believe it was draft 2. And help me if I'm understanding incorrectly. And that failed. We are on a draft 4 as amended.
Mm-hmm.
And so I think we put it before the body and move forward here. So the motion to postpone. The motion is to postpone this agenda item to the October meeting. Back to you, Member Bogus.
Thank you. So these code lines were opened up in the last legislative session. They were voted on, and we've got multiple, and when I say multiple, like over and over again, parts of this rule that are out of alignment with Utah code. They're in conflict with themselves. They're in conflict with other rules, and the drafts presented don't recognize or remedy those conflicts. So when we're here and we're passing a rule that's in conflict with itself and then in conflict with other rules, I really do think we need to work this out and not do this until we are in a space where it's all remedied.
Member Davis.
If we pass this committee work today, it's still, because the L&L committee considered it last Friday, it will still be on the agenda in October. Am I right? So even if we pass the committee work today, for now, it could be changed again during the report out next month. Is that correct? Okay, I just want to make sure seems like we have an opportunity, could do both at this time.
Member Earl.
It's my understanding that these rules, the intent is, because they're up for their 5-year review, is to actually, from what came out of committee, is to put together a committee to review that, which would include any provisions that someone felt were still out of compliance with code. Is that an accurate statement? Is that what came out of committee on Friday? And if so, I don't understand. I mean, if there's a larger, major discussions to take place over alignment or something, that does seem like something that would be included or could be included within that framework. So I don't know if someone from that committee could speak to that or the intent.
Yeah, please, Chair Carey.
Yeah, it's what came out of committee was regarding the UPAC rules. There were 2 motions that came out, and one was that we would take the group of UPAC proposals submitted by Board Member Bogus, and they would be reviewed internally and made ready for the board at the October meeting. The second motion that came out of committee was that we would recommend to board leadership that a working group be put together, specifically because the UPAC rules are up for their 5-year review. And we thought it best that instead of acting unilaterally on this matter, that we do bring in parents, educators, partners to really do a top to bottom review of all the UPAC rules. So if that answers the question, thank you, Chair.
Yeah, so I think that, I don't think, what I'm understanding is we have these rules before us, these amendments before us. from what came out of committee that Chair Carey just shared, so a recommendation to put thought in this, which will take time. This is not a thing that will be solved even in this meeting. However, I do not believe that the recommended amendments, the amendments that we've made already, have put us out of line with law, right? I don't know if that's the concern for me. But no, and I'm not saying it is an accusation. I'm just saying I'm looking at what's come before us. And so if I'm hearing correctly, there is some concerns that this rule in its entirety may be missing some things. And so it needs a deeper look, is what I'm understanding. So, well, hold on a second. I'm trying to make sure that we're all kind of understanding where we are with this process. So we have a draft 4 before us. In committee, it was discussed the several UPAC rules, and we've just heard that, I know, spoiler for next month, right? We've just heard that there's going to be some recommendations coming forward to put a task force or committee or work group to get down to the bottom of this. So with that in mind, that will cue us up for our motion, which I see lights and we'll still get to them. But with that in mind, our motion before the board is the motion to postpone to October meeting. Member Bogus.
Thank you. So this rule itself is in conflict with itself. And then it also has multiple facets that are in conflict with what is now currently 215 and 210. And those things are in conflict. And the available drafts don't reconcile that. None of the drafts 4 reconcile those. And none of them are currently in alignment with our legislative code. We have code issues that need to be addressed. And I think we need to postpone this and have a robust discussion in the October board meeting.
So the motion before the board is to postpone this agenda item to the October meeting. Seeing no lights, let's go ahead and vote. Member
Brenton's a no.
Thank you, Member Brenton.
Green's a yes.
Green, thank you, Member Green.
Booth is a yes.
Member Booth, thank you, yes. Member Hall?
Hall is a no. No.
Member Hall is a no, thank you. Is Member Real online, or is she? That fails. 11 opposed, 3 in favor. Those in favor being Member Booth, Member Kelly, and Member Green. Okay. So the underlying motion then is that the board approve R277-217 draft 4 as amended. Seeing no lights, let's vote. Oh, did you need to? Oh, Vice Chair Wood.
I would make a motion to divide A, B, and C to vote on them separately.
Will you repeat that motion? The motion to divide?
I move to divide between A, B, and C.
Okay. On the amended language. Okay. So there's a move to divide A, B, and C from subsection 10 that was just adopted into the rule. Is there a second? Back to you, Vice Chair Wood.
I do want to do. I want to be able to vote. The heading is fine. I want to be able to vote individually between A, B, and C because I like A and I like C, and I want to vote no on B.
Well, so the motion to devote, the motion has already been accepted. So I guess I'm asking to divide from what they're already in the rule. We've already voted on them. Yes, on subsection 10. So you would need to put a motion to strike A, B, or C. Please, Vice
I
Chair
will
Wood.
strike B and lose, but I can have my way. Thank you.
Thank you. Okay. The motion is to strike 10B and lose. Did I capture that? Okay. With honor, yes. I'm just trying to get it as stated. No. So I'm sorry, Vice Chair Wood. Yep. We'll get it on the screen here.
It's line 166 and 167.
So,
providing
yeah.
relevant information within the educator's knowledge or possession. Because I believe 159 through 161 already requires that of them.
So, okay. So the motion, again, restating the motion is to, for clarity, strike lines 166 and 167 from the amended draft 4. And we have a second. You semi-spoke to that. Do you want to speak additionally? Okay. And Member Bogus.
I don't have a question. No, I do have a question. I'm sorry. May I query the maker of the motion? What is your why?
I appreciate that lines 159 through 161 clarifies truthful, accurate, complete information to the appropriate authority. And I know we've already gone through this discussion with Member Carey and Member Earl, that they believe it's related specifically to the investigations. And I want to be able to vote no. That is my why.
Does that answer your question, Member Bogus?
Yeah, thanks.
Okay, so the motion before the board then is that we strike lines 166 and 167 from the amended rule. Let's go ahead and vote. Member Hall?
No.
Member Booth?
Booth is yes.
Thank you. Member Hall is a no. Member Booth is a yes. Member Brenton?
No.
Member Brenton is a no. Member Green?
No.
Member Green is no. Okay, thank you. There it is. We've got that motion fails. 9 opposed, 6 in favor. Those in favor being Member Bogus, Member Bollinger, Member Booth, Member Reel, Member Lear, and Member Wood. This brings us back to our underlying motion, and that is that the board approve R277-217 draft 4 as amended. Let's vote. Member Booth?
Yes.
Member Booth is a yes. Member Green?
No.
Member Green is no. Member Brenton?
Yes.
Member Brenton is yes. Member Hall?
Yes.
Member Hall is yes. Thank you. Member Booth, will you restate your motion, your vote? Sorry.
Yes.
Thank you. Okay, that passes. 13 in favor, 2 opposed. Those opposed being Member Green and Member Bogus. Chair Carey.
Thank you, Chair. The next matter is item 10.3. And this is R277-210, Utah Professional Practices Advisory Commission definitions. And the motion for the board is that the board approve R277-210 definitions draft 2 on second and final reading. And with the chair's permission, I would speak to the motion.
It's been stated. Go ahead.
So the changes that were just adopted by the board for R277-217 required additions and changes to our UPAC definitions. And if we turn to lines 102 to 103, you'll see that consensual sexual activity, that definition has now been added to the rule, as well as I believe there was one other, page, lines 252 to 253. Recent graduate was also defined to mean an individual within 6 months of graduating or officially exiting from high school. Thank you, Chair.
Thank you. Member Earl?
I want to make a substitute motion that we adopt draft 4 that has one or two revisions in it.
There's a substitute motion to adopt draft 4. Do we have a second? Second. We have a second. Back to you, Member Earl.
Yeah, so this is the same as what came out of committee. It's the draft 2, but was added into it that on line 43, boundary violation means crossing verbal, physical, emotional, or social lines with a student or minor. Minor is the key piece here. And as we go down for a definition later, on line 228, that here we would define minor as an individual under the age of 18 or an individual who an educator reasonably believes is under the age of 18 under the circumstances of the interaction. And so here it's just this captures those individuals that a educator believes or is engaging in conduct that may be boundary violations that that are engaging with students that are below, are from their understanding, are under 18, if I'm saying that right.
Thank you, Member Earl. I've got lights from Member Davis, Member Bogus, then Member Carey. Member Davis. Remember, the motion is draft 4 that we're speaking to.
Okay, I appreciate the clarification that this came out of committee with these minor changes. My question is on line 44. If we add the words with a student or minor, then does that preclude, responsible behavior between adults? My worry is that by adding that in, it takes the other out, presumably.
Is that, I don't know where that is. I had the same question, and I don't know if that's directed to the maker of the motion. Member Earl? Let's see here.
Yeah, and if you look just down, just below that, I mean, there's clarifications there. It says boundary violation may include the following, depending on, and it does primarily focus on students. You're saying that it could be more restrictive and not as broad. Let me think on that for just a minute, but I do think most of these are engagement with the student themselves, and that's why the provision is there.
Can we ask Director Rasmussen if that changes anything? I mean, can an educator have boundary violations against another educator? I think that's the question, right?
We already have other standards that apply to communications or misconduct that may occur between an educator and another adult, for example, a colleague. I don't consider boundary violations to be interactions with colleagues. I would consider that to be students or minors, so I don't think omitting adults here would be problematic.
Yeah, Member Davis, follow up.
Okay, so, sorry, where is that? Where do we have that where adult on adult is outlined?
There are, in our 277, 217, we do have standards about communications and harassment of adults, community members.
Okay. Thank you.
I've got Member Bogus, then Member Carey.
Thank you, Chair. So once again, we're in a space where we're defining the word minor, but we just passed a rule that included the word minor, and it means of lesser importance. So until we reconcile these one with another, we're now defining a word and using it completely inappropriately in multiple other rules. So when we add this definition here, it forces us to recall the one we just passed, and we're going to have to amend multiple other rules to reconcile the word minor, meaning of lesser offense.
Member Carey.
Thank you, Chair. A question for the maker of the motion. On lines 228 to 231, I just want to make sure that I understand what's happening here, and that is this language to encompass those interactions where you have someone over the age of 18 pretending or purporting to be someone under the age of 18? Is that what this rule is meant to capture?
Yeah, I think it's meant to capture the intent of the educator, knowing that they're engaging with someone who they believe is under the age of 18, but it could be an investigation. It could be an officer related to sexual content. Right, that is someone that's over, so that would be the intent. And yet the educator themselves would be engaging, knowing that they, or what they thought was a minor.
Okay, thank you. Thank you, Chair.
Thank you. Just for clarity, both of us, maybe all three of us, jumped on this. Okay, let's look at 217 briefly, and there might be the other. I didn't look at 215 or 211, but minor is defined in 217 is not defined, but it does in the three references that we've seen. It says with a minor student, right? And so it's referring to the individual. The second reference, student or minor, and then the third reference, student or minor. So it does not, I just want to make it, I know there is the noun and verb thing going on here, but anyway. So the motion then before the board is to adopt draft 4. We've got a light again from Member Bogus. Go ahead.
I would move to amend line number, sorry. You forced me to move my mouse, Matt. Yes, you did.
Power you have, it's unbelievable. You're moving her mouse.
Draft this one. Line number 29. And I would move that we add, which is based upon the preponderance of the evidence after 601.
Which line? Apologies.
Line 29.
Line 21 after 601.
We put a comma, and which is based on a preponderance of evidence.
Okay, so there's a motion that says on line 29 after 601 that the board add the language. Let's get it up here. Remember, Bogus, keep an eye on that screen. Sure. Member Lear, point of information.
Working on one earlier amendment. Now we've switched to a completely different amendment. So we've not voted on the first. Are we proposing to now vote on them all?
So the motion that is before the body is to move draft 4, and which encompasses that amendment, which was
And so now Member Bogus wants to also add more things to draft 4.
yes.
Gotcha.
Okay.
Thank you. Clarification.
Member Bogus, does that meet is that your motion?
My preference is that it would say, and which is based on a preponderance of evidence. You can put I don't know that it matters, but my motion was a preponderance of evidence. Yep.
The motion that has been presented is that the board amend draft 4 by adding and which is based upon a preponderance of evidence after line 29. Do we have second? Hearing no second, let's move on. The underlying motion then is that the board approve draft or R277-210 draft 4. Member Bogus.
Thank you, sir. Sorry, I'm finding it.
as you're finding it, I want to not remind, this is to let the board know these rules fall similarly to what we had a discussion around 217, where this will also be part of the later discussion, as mentioned by Chair Carey, that came out of committee. So rules 217, 210, 215, and 211. Just a information item. Go ahead, Member Bogus.
I move to add a definition of harassment after grandma.
There's a motion to add definition of harassment after grandma. And do you have that definition, or are you
Yep.
pulling that from somewhere? Go ahead.
Nope. It would be in quotes harassment, or in quotes harass means conduct or to engage in conduct that is unwelcome, pervasive, demeaning, ridiculing, derisive, or coercive, and results in a hostile or offensive or intimidating work or education environment. Oh, do you want me to text it to you? Who's running?
Member Bogus, will you let us know when that is correct on the screen?
That is correct. Yes. I was just being respectful, Chair.
Okay, so the motion before the board then is that the board amend draft 4 by adding a definition of harassment. Yeah, it's not before the proposed motion, sorry, is that the board amend draft 4 by adding a definition of harassment. Harassment or harass means conduct or to engage in conduct that is unwelcome, pervasive, demeaning, ridiculing, derisive, or coercive, and results in a hostile, offensive, or intimidating work or education environment. Do we have a second?
Second.
There's a second. Back to you, Member Bogus.
Thank you. Well, we use this word repeatedly, but it has no definition, and it needs a definition. And using it in both the verb and the noun form, I think we've covered it all in a single line item.
Member Carey?
This would be a point of information. Is there a statutory definition of harassment?
We went to, as vice chairs are type, AAG, Beal, maybe you found, we didn't find one. We found hazing, we found bullying, cyberbullying, all the things, no harassment. AAG Beal?
Okay, typically in these codes, we've used case law definition. There is a harassment definition, but it's under like the criminal code. So.
Yeah, and the second question is, maybe this is for AAG Beal, maybe for Director Rasmussen through the chair. Intimidating work or education environment. Is there a legal distinction between those two areas?
I mean, I can give you, I think, just maybe this isn't a legal opinion, but for me, work obviously could include things like a staff meeting, things that aren't inclusive of actually being in school hours. And education environment could include things that aren't necessarily happening like during school hours, like a football game or a basketball game that's occurring after school, but is still an education environment, I would say.
Follow up? Could education environment include those occasions where the educator is not working but on their own time? Is it broad enough to encompass that kind of behavior?
Potentially, depending on the context. I mean, if they're attending a school event, but they're not on the clock, right? They're attending a football game as a parent, but then engaging in some kind of contact. I certainly think that could rise to that level.
Okay, thank you. Thank you, Chair.
Member Davis?
I have a substitute motion. I move that we define harassment as aggressive pressure or intimidation, and I'd like to speak to it if I get a second.
There's a substitute motion to define harassment as, let's just wait till we get it on the screen here, as aggressive. Will you restate that?
Aggressive pressure or intimidation.
As aggressive pressure or intimidation. Is there a second? Second, Member Davis, go ahead.
Thank you. I don't disagree that we need a definition of harassment. I agree with Member Bogus. But I think this one is the Oxford definition of harassment, and it's more widely understood and known. And also, I think it covers a multitude of places and questions, just like Member Carey was asking. For example, when I worked in schools, there were times when I had to enact a disciplinary situation for something that happened totally off campus so I just think that this is the more understood definition of harassment, and it allows for all of these things that we're discussing.
Can I just ask, I don't jump in very often, I'm going to share a brief story. I know, in the zero time that we have, I was in a workroom with two of my colleagues. They are friends of mine. We are all 6'4" and above. And this 5'5" woman came in, and we were eating ribs that I had smoked the day before. And I didn't even notice this woman, but my wife happened to work with me. And later when I got home, she told me that this woman was terrified that these three giant men were eating ribs together, laughing and like cavemen, which we probably were. She was quite intimidated. Please, Member Davis.
I think that situation is different because you didn't do anything to her. She walked in and saw you all eating your food and felt intimidated, but you weren't harassing her. You weren't, saying to her,
Okay.
You are less than us because you're not joining in these ribs and you should eat this right now with us. Like I felt on burrito mornings when I worked with very big men and I was the only little person.
I just want to make sure. Again, I'm jumping here. I just want to make sure that we are protecting. It's a difficult balance, right? Because what one perceives as enjoying a moment, the other would perceive as harassment, and that happens all the time. It really does. And I'm not using my story in particular. But it could happen. So regardless, the motion before the board is that the board define harassment as aggressive pressure or intimidation. This comes from where, again, the Oxford Dictionary. So this is not new, or this is not something that Member Davis just came up with. I've got Member Earl, Member Lear, then Member Bogus.
Thank you. I guess I'm going off of what we did last week. We removed hostile, intimidating, abusive, offensive, and oppressive, which was previously in the rule. But then under harassment, we're adding in unwelcome, pervasive, demeaning, on and on and on. We're adding in these pieces that last week was not okay to have all these moving parts. But then we're just putting it under another title. And I guess if the argument was last week to not overcomplicate things, but then we just We just did it. I would be for the motion that Board Member Davis put forward, and maybe we can seek the legislature to clarify what they would like that to look like, both in this rule, and we have several rules, right? Our bullying rule and that, to make sure that we're in alignment both legally and otherwise. But the idea of unwelcome, if something's unwelcome and it results in a hostile environment, and maybe the educator doesn't realize it's a hostile environment. I just think there's some ambiguity here that we weren't willing to do last week, but we might be considering this week. I would go with the simplification here.
Member Lear?
Thank you. I think this is another great example of why we need a holistic discussion of these issues. There are multiple definitions of harassment in our administrative rules, and I, for one, would prefer the board coming up with our own definitions for our rules. So this is, in my mind, an example of why we need to discuss all these rules together, these definitions similarly, and just to your point, Member Chair, because I can't resist, harassment is in the eye of the beholder. And if you feel harassed, you have a right to be able to report that. And so I think that's another factor that needs to be discussed. There's no mention of protected classes in this. So I think this is an example of piecemealing these definitions and rules. And yes, the ship that overcomplicates things has already sailed. So we're on that, I can't think of the further maritime analogy, but we're already going down that road, to mix metaphors. So that part I don't care about. I just would like to have a single definition of harassment. There's one in 609, there's one in 613, there's at least one in the UPAC rules. There are other definitions. So I would argue for leaving this alone right now and then discussing it with the other rules. Thanks.
Member Bogus, then Member Carey, then Member Davis.
Thank you. So I would argue that this is completely different from what we discussed last week. For example, there's an "and" here. And the words last week were things that teachers were supposed to somehow magically wave a wand and prevent. These are things that have to meet every definition in order to be considered harassment. So I would argue against Member Davis's motion, because the initial definition encompasses this, where it is unwelcome, pervasive, demeaning, and where we're in a space where we meet multiple benchmarks before we start getting into the space of crying because we feel a certain way. And if we're talking about feelings, we use the word feelings in many of our UPAC rules. So when we use this one, my concern is if you issue instruction, classroom management does involve an element of a power structure, which includes intimidation. So if we start defining harassment as intimidation, and you ask a kid to move to the front row and you expect them to do it, and they think you are intimidating, we're in a whole new ballgame of crazy. And so I would just argue against this motion. I don't think it's clear. I don't think it's appropriate. And it also does not encompass the word harass, which is a word we use and we need to define. Thank you.
Member Carey?
Thank you, Chair. I would speak in favor of the motion. I do like the definitions in the original motion. My concern, however, is that education environment. I'm concerned that the ambiguity would rope in educators and others who, even if they're ultimately vindicated, it would just bring them into this investigative process unnecessarily. The other concern I have is the word pervasive. Courts have long ruled that a single act can constitute harassment if it's egregious enough. And by putting pervasive, we are really saying that it has to be more than one or possibly two or three acts, and I think that's unnecessarily restrictive. Thank you.
Thank you. I've got Member Davis, Member Reel, Member Bogus. I'm going to go to Member Reel. I know Member Davis, you've spoken to this. Member Bogus has spoken to this. I'll still come. I'll honor the lights that are on, but we don't have a lot of time today, board members. So please be mindful of that. Member Reel, go ahead.
Thank you, Chair. I'd just like to call the question.
The motion is to call the question. There's a second? It's non-debatable. Let's go ahead and vote. Member Green,
No.
Member Hall. Oh. Sorry, one second. We're getting the voting ready. Yeah. There it is. Member Green was a no. Member Hall. Member Booth.
No.
Member Booth is a no. Member Brenton.
No.
Member Brenton is no. So that motion fails. 7 in favor, 7 against. Those against were Member Carey, Member Longacre, Member Brenton, Member Davis, Member Booth, Member Bogus, and Member Green. So we are back to our substitute motion by Member Davis, which is that the board define harassment as aggressive pressure or intimidation. I've got Member Davis, then Member Bogus, and then Vice Chair Wood.
Thank you. I'd just like to quickly read the definition in,
Point of order. That's an amendment. That can't be a substitute motion because the original motion is to adopt draft 4.
It's
So she can amend the amendment, but she can't substitute the amendment.
Sure. The amendment
Okay.
before us is that the board define harassment as aggressive pressure or intimidation.
I'd just
Go
like to
ahead.
read the one that we have in 609. It's harassment and discrimination-free learning means a learning environment which is a student is treated fairly regardless of the student's characteristics, including race, color, religion, sex, national origin, or disability, and in which a student's ability to participate in or benefit from the services, activities, or opportunities offered is not limited to or interfered with by the conduct that is physically threatening, harmful, or humiliating. So I do agree we need to get a holistic look and get our definitions aligned. And so I may not even vote for my own motion today because I think we got to figure out, but at least it's out there on the floor and the committee that meets can know, do they want something shorter like this or do they want to go with what we have in 609? But certainly we should probably get, some consistency and continuity. Yeah.
Okay. So for the sake of clarity, you can have substitute motion on an amendment. It was conferred. This is then, if it was put forth as a substitute motion from Member Davis, it stands as a substitute motion, although she did just speak against her motion. The motion before the board is that the board define harassment as aggressive pressure or intimidation. Let's vote. Member Booth.
No.
Member Booth is a no. Member Brenton.
Brenton's a no.
Member Brenton is a no. Member Green.
No.
Member Green is a no. Member Hall, is Member Hall back with us? Okay, that motion fails. 14 against, 1 absent. This brings us back to our underlying motion then, which is, so if the substitute fails, we go back to the motion of Member Bogus's motion that the board amend draft 4 by adding a definition of harassment. Harassment or harass means conduct or to engage in conduct that is unwelcome, pervasive, demeaning, ridiculing, derisive, or coercive, and results in a hostile, offensive, or intimidating work or education environment. Let's go ahead and vote. Member Brenton?
No.
Member Booth?
No.
Member Green?
No.
Member Booth, clarify you were a no vote. Is that correct?
That is correct.
Thank you. That fails. 13 in opposition, 1 in favor. That favorable vote coming from Member Bogus. We are back to the underlying motion, which is that the board approve R277-210 draft 4. Let's vote. Member Green,
No.
Member Booth,
No.
Member Green is a no. Let's pause for a second. Remember, Member Green is a no. Member Booth is a no. Member Brenton? Oh, sorry.
Yes.
Member Brenton is yes. Member Hall is not with us yet. We need 2 more, 1 more. That passes 11 in favor, 3 opposed. Those opposed coming from Member Green, Member Booth, and Member Bogus. Chair Carey.
So I believe that we are on 10.4, R277-215, Utah Professional Practices Advisory Commission, UPAC, Disciplinary Rebuttable Presumptions. And the motion before the board is that the board approve R277-215, Utah Professional Practices Advisory Commission, UPAC, Disciplinary Rebuttable Presumptions, Draft 2, on second and final reading.
The motion has been stated. Member Earl?
Yes, just come back to me in just one moment. Sorry. I
Okay.
gotta.
Member Bogus?
I move that we send this back to the board in October because we have multiple definitions that we just adopted that are now in conflict with this rule. And until we amend those definitions, this rule is crazyville.
So the motion is to postpone to October. Do we have a second?
Second.
There's a second. Member Bogus, I know you spoke to it. Do you want to speak more?
Thank you, Chair. I just don't know what we're doing here. We're one right after another. We just passed one and then we passed another that conflicts with the one we just passed. And now we're in a new place where we're already in conflict, but we're going to pass this, but it's in conflict with what we just passed. It's crazyville. I don't know why we think we're doing good work here. I think we need to really think about what we're doing. Postpone this to the October board meeting, do the work that we need to do, and then move forward with it at that time. Thank you.
Member Earl?
I have a motion after we vote on this. So
Okay. I'm going to speak against this motion just briefly. The work has been being done. I want the public to understand that this isn't something that we're just sitting down now looking at this saying, okay, let's vote, right? Work has been done for days, hours, months, a long time. A lot of work has gone into this. So I just want to make sure that the public understands that this is not just we get this, yesterday or this morning and we're voting on it now. So with that, the motion before the board then is that the board postpone this agenda item, specifically R277-215, until the October board meeting. Let's vote. Member Green?
Yes.
Member Green is a yes. Member Brenton?
No.
Member Brenton is a no. Member Booth?
No.
And Member Booth is no. Thank you. That motion fails. 11 opposed, 3 in favor. Those in favor being Member Green, Member Bogus, and Member Davis. Member Earl.
And sorry, I was trying to seek some clarification just because it wasn't, okay, let me make the motion. So I would just move that we substitute draft 3 for 215.
There's a motion to or a substitute motion to approve R277-215 draft 3. Do we have a second? There's a second. Member Earl?
Yeah, so the only change here would be that, and it aligns now with the other items, which is what needs to happen, is that on line 39, engages in boundary violation with a student or minor. Student or minor is the added piece here, which goes directly to our previous question. That is sexual in nature, that is not sexually explicit conduct. So it now is in alignment.
Member Lear?
I ask a question, may I ask a question of the maker of the motion? We have a definition of sexual conduct, I think it is. What is sexual in nature? Is that, just help me understand how you would define, and how educators who are
So I just
needing
wanna-
to understand this, is it?
I just want to be clear, the only thing, I'm not adding sexual in nature here. The only thing that's added is the student and minor,
the
with
student.
student or
Okay.
minor. I'm not adding the other pieces,
That
but we
came
can
earlier.
get a different clarification
Sorry.
on that if you want.
No,
Okay.
enough said, thank you.
Okay.
Thank you. Member Bogus?
So this is absolutely not in alignment in any way, shape, or form. They might have factions of it that align, but to say that this aligns with our other rules is not truthful. It might have amendments that create alignment in blue areas, but we've got words in this that are now defined, that are now used out of context. It's not in alignment at all.
Member Earl?
I look forward to additional discussions from this body and from the general, from educators and others for that very purpose. If there are some things that need to be greater clarity, whatever needs to happen. But I think that's the process we need to go through. So in the meantime, these were minor changes, and they did, that some of the changes that were brought through committee were to help us with what Katie Hall's bill was this last year. So once again, if there's some need for additional clarification, I look forward to those additional discussions.
Member Bogus?
Yet these amendments do not put us into alignment with Member Hall's bill. Even with these amendments, we're still out of alignment with the code that was adopted in 2024.
So the motion before the board then is that the board approve R277-215 draft 3. Member Davis?
Do we need to put the words and or? Because I've got to get back to draft 3 now, but
No, they're saying no.
what if you're an 18-year-old graduate? Are you still protected for 6 months? No? If you're not a minor, if you're, let me get back to draft 3.
What line is that?
Okay, so then my question is to legal folks here.
Can we get a line number that you're specifically looking at?
44, but also it goes back up to, does 39 is the part where you add in a student or minor?
Yes, so 39 has the with a student or minor as green. I believe that's the draft 3. 44 was on draft 2, if I understand correctly, and you're looking at 44 and wondering if there should be an.
You know what? I think I just answered my own question. Thank you.
Those are the best questions. Okay. So the motion before the board then is that the board approve R277-215 draft 3. Let's vote. Member Booth?
No.
Member Booth is no. Thank you. Member Green?
No.
No from Member Green. Member Brinton?
No.
No from Member Brinton. Okay. Thank you. And we have Member Hall absent. That motion passes 10 in favor, 4 opposed. Those opposed being Member Brinton, Member Green, Member Booth, and Member Bogus. Back to you, Chair Carey.
Thank you, Chair. With the Chair's permission, I'd like to go out of order. There is one more UPAC rule R277-211 that is listed as item 10.8. And just because we're doing all UPAC, if that would be appropriate.
Please, I don't see any disgruntled looks. Let's do it.
So item 10.8 is R277-211, Utah Professional Practices Advisory Commission, UPAC, Rules of Procedure, Notification to Educators, Complaints, and Final Disciplinary Actions. And the motion before the board is that the board approve R277-211, Utah Professional Practices Advisory Commission, UPAC, Rules of Procedure, Notification to Educators, Complaints, and Final Disciplinary Actions, Draft 2.
Thank you, Chair Carey. The motion's been stated. Member Bogus.
I just have a couple questions here. If I could direct our attention to lines 117 and then move down to 130. I don't think whoever proposed this amendment really thought this through, because these things are on their face in conflict with one another. So, for example, line 117 says, the investigator shall prioritize investigations over other longer pending investigations. And then it goes over and it says, but if they want to, they can prioritize these over the other longer pending investigations with no prohibition of superseding 117 through 122. And so this language on its face it's self-contradictory.
Is there who's that question directed to? And I don't know if it was a question, or I know you made some comments there. What's your question, and who's that directed to, Member Bogus?
Well, my
please?
question is, this just creates chaos. How can we frame this language so we don't have chaos? $117 and went through 122, and then 123 through 130. But in particular, 117 and 118, and then 123 and 124.
I don't see any lights jumping to a response, but we can take a second and review.
Is there a motion that needs a second on the table?
There is no motion right now. The underlying motion is to adopt or accept draft 2. Member Bogus put forth some questions regarding lines 117 through 122. Member Earl, go ahead.
Just a couple of responses to that. One, that investigator shall, there's a shall there and there's a may down below. In other words, we're trying to address both provisions. In other words, the pieces of the law that we were asked to address, but also that flexibility that there may be times when the investigator needs to prioritize. So it allows some flexibility in there, but also trying to get to those key things that need to happen. For example, allegations against the educator suggest an ongoing risk to students, which, if we've got an ongoing risk going on, that would need to be prioritized. The second one, the case needs to be expedited to accommodate a crucial witness if there's a need for a specific witness to, for whatever reason. And then the last one, the presumed discipline would result in a loss of license of 3 years or longer. So it's trying to put some pieces in there that would create that prioritization. And then down below with that the investigator may prioritize, listing several indicated pieces there, so that there is some order instead of just as they come along, we'll take them, or ones are pushed off forever. So
Member Bogus, then Member Davis, Member Carey.
So that doesn't really answer the question. So let's say, just as an example, we have allegations of an educator that suggest ongoing risk, but we have secondary allegations that create uncertainty for a community. And the way this is written, we can actually flip-flop 4 and 5. So
I know you're paused. I wasn't going to move on until.
Well, it just doesn't answer the question. These are in conflict with each other. And unless we put some sort of caveat in 5, we just present a space where we really haven't changed anything for the better. We've just created language that says we can continue to in mayhem. I don't know.
Member Davis.
What seems like the shall just prioritizes that section over the may. But my question was, do on lines 117 through 121, and this is probably Chair through you to Director Rasmussen, do we have, is this already practiced? Do we do this already? Do we have the flexibility to prioritize cases of greater risk? And if so, then have a quick follow-up if so.
Director Rasmussen, if you're willing.
So
Line
we have-
117 to 121.
So the attorneys on my team have used some discretion in some of these matters. It's not an adopted policy. Some of the things that have been identified as mandatory priorities have not been fixed in policy before, but we do use some discretion in prioritizing cases right now. This is just trying to make it more transparent.
Yeah. Okay. So may I follow up? So it sounds like we are doing this already and it's required in code. So this language would just add clarity, it sounds like, to what's already happening. And then my other question is, if that's already happening and investigators can use risk to kind of determine the order of investigations, then could we as board members also use levels of risk in our deliberations along with the presumptions to add flexibility to what things we do?
I'm not sure I understand how that would play out. I think you certainly, as a board member, can take into consideration risk or anything else you deem appropriate when you're deliberating cases.
Thank you. It's just something that I've been thinking about as of late. Thank you.
Member Carey.
Yeah, I have a similar concern to Board Member Bogus, which is I know that we use the word shall in line 117 and we use the word may in 123, but the way it is written is that, and I'd like to direct this to Director Rasmussen, because the discretion that's provided could result, as I read it, in the investigator giving equal priority or perhaps more priority to the items listed in 123 through 130 than over lines 117 to 122. And I know that when this language was put together, there was lots of discussion on the feeling was that the items listed in lines 117 through 122 should take carte blanche priority. And now I'm concerned as I read this that even though that was my intent, I don't know if this language accomplishes that. So with your permission, Chair, Director Rasmussen, do you see what I'm saying? Even though it says shall and may, I see circumstances where an investigator could prioritize lines 123 through 130 over those outlined in 117 versus 122.
I respectfully don't read it that way. I think where it says shall prioritize, that is mandatory. That's first priority always. And where it says may prioritize below, to me, that's subsidiary, subservient to the language above it. So I don't share that concern.
Okay, thank you, Chair.
Member Lear.
I think this is another example that bears more discussion. I can read this the way that Member Carey is describing, but I also think that it's possible that there could be a very, very obscure minimal risk to students that would merit a different understanding and consideration from lines 123 down. I think this brings in overtones of criminal law in a reverse way that don't make me comfortable. And I don't need to belabor all of that for all of you, but I will be voting no because I think it's not, I think this is something that bears more discussion, both because of issues that Member Carey brings up and if that's the will of a bigger group of stakeholders, I could go along with that. But just as written, I can't go along with that where I feel that sometimes educators are at a extreme huge disadvantage, and I'm just waiting for the comment that says any minor damage to a child overwhelms any rights of anybody else anytime. But I feel like this bears more there's a need for greater discussion on this.
Okay, we are at the motion, which is to, I believe it's accept draft, or that approve, sorry, the motion before the board is that the board approve R277-211 Utah Professional Practices Advisory Commission, UPAC, Rules of Procedure, Notification to Educators, Complaints, and Final Disciplinary Actions, Draft 2. Member Bogus.
Thank you. I move to strike lines 123 through 130. Sorry, you guys, I'm sorry. Those are my classroom alarms.
There's a
I've shut
motion
them off, but they
to
don't.
strike lines 123 through 130. Do we have a second?
Second for
There's a,
discussion.
there's a second. Member Bogus.
I think if I do think that lines 117 through 122 are good additions, but the way this is written, they're just in conflict with each other. And so if we're bringing this back month after month, then hopefully we can fix it within a month. But until such time, I think we need to strike these lines.
Member Davis, your light came on fairly closely. I don't know if it's to this motion or to the overall.
I have a substitute motion
Okay.
that we move draft 1.
There is
If I get a second, that's the one that came out of committee, and I'd like to speak to it.
the draft, just for clarity, I believe Chair Carey
Did draft 2 come out of committee?
draft 2 came out of committee.
Okay, so let me.
The committee motion is on the, well, it was on the floor. Then we have a motion to amend by Member Bogus. So are you wanting to move draft 1?
Draft 1 has the language in both of these sections combined in a way that makes more sense. So can I just look at draft 2 really quickly?
Yes, so I'll circle.
Again?
We'll come back to you, but until then, I guess draft 2 is on, or not draft 2. The motion that the board amend draft 2 by striking lines 123 through 130. Member Davis, are you ready to move forward? it is possible to take a 5-minute break. Member Earl, are you okay with that? Okay, let's saunter for 5. We'll be back. Thank you. Board members, let's go ahead and regather. And we are removing this. Sorry, we looked at Robert's Rules of Order. A substitute motion to move a draft is not in order at this time. So this brings us back to the motion to amend, and that is that the board amend draft 2 by striking lines 123 through 130. I've got Member Davis's light on with no Member Davis, so we are going to move to Member Carey. Okay, we've got 8, and we've got online people, I hope. Okay, Member Carey, please.
No, I was going to speak to the substitute motion. I was going to speak in favor of that. But if the timing doesn't permit that, I don't have anything to say regarding the motion to amend.
Thank you. Do we know where Member Davis is? Okay, she's just out for a second. So I just want to respectfully allow her to understand, 1, we're not doing that substitute as of now, and then 2, if she wants to speak to this motion. And I don't know if we have any hands online. Okay. A question from Member Carey. Go ahead.
And this chair best probably directed to Director Rasmussen, maybe Board Member Earl. The only difference that I could detect between draft 1 and draft 2 are the language. Is it the? Could you tell me the lines that are different between draft 1 and draft 2?
Member, who would you like that? Is that Director
Director
Rasmussen?
If I may.
Please.
So lines 117 through 130 were amended in draft 2. You can see that by the change in the color coding.
And then one more question, Chair. And then Director Rasmussen, no other changes outside of those?
No, I don't believe so.
Okay, thank you.
Thank you. I was hoping that'd take a little longer. Member Earl.
So we can't make you're saying we can't make a substitute, we can't substitute this for the other?
It's not in order at the time. Again, looking over Robert's rules. So if we wanted to make a substitute motion on these lines, we could do that. But if we wanted to make
because there's an amendment, is that
yes,
why?
Yes. Yeah. So the amendment before the board is to strike lines 123 to 130. So if there were a substitute motion regarding these lines or this area, that's in order. But for the entire draft, we would need to wait to get back to.
Okay. So let's vote on this and then we can get back to. Yeah.
Yeah. So I've got Member Lear with a point of order.
I feel well, let me ask it as a question. The members that are online cannot see the board. Is that right? The voting board?
That's correct.
When we begin voting?
When we vote online, when we vote with our machines,
Yes.
the members online cannot see that. Is that correct?
That's correct.
With that in mind, I wonder if we should not be able to vote verbally so that the members online are better informed about how the votes are looking.
I am fine to do that. We actually, Sybil prepared us. So if that's the direction of the board, I'm fine to do a voice vote and everybody hears everybody's vote.
I know that is frustrating. I've been online and I've not been able to see others' votes, and I like to see others' votes as I vote. So I would prefer that, even though it's more time consuming.
Okay, we will move in that direction. We're going to take more time there. So let's see if we can shave time in other areas. We've got a motion before the board that the board amend draft 2 by striking lines 123 through 130. Member Davis, do you want to speak to this motion?
No, I have one waiting.
Okay. Member Bogus, to this motion?
No, considering the conversation, without objection, I would withdraw the motion.
it does belong to the body. Let's go ahead and vote on this motion, and that is that the Board amend draft 2 by striking lines 123 through 130. Let's do a roll call vote. I'll try to. Okay. I will start with myself here, and I'm going to vote no. I have to vote last. Well, it's too late. I've already voted. Is Member Hall back with us? Member Green?
No.
Member Earl? Member Davis? Member Brenton?
No.
Member Booth?
No.
Member Bollinger?
No.
Member Bogus?
No.
Member Kelly?
No.
Member Carey? Member Lear? Member Longacre? Member Reel? And Member Wood?
No.
Okay, that motion fails. 14 opposed, 1 absent. Member Davis?
Yeah, I have a substitute motion that the board move draft 1, and with a second, I'd like to speak to it.
There's a motion that the board move. Are we saying move or draft or accept or what's the adopt? What's
Adopt.
The amend? Yeah, adopt. So, sorry, Member Davis, what verbiage are you using here?
I think either can work
Yeah.
personally, but
So
whichever
we-
verb.
If
you
adopt
prefer.
works, that's fine.
That's
Sorry. On the other ones, it says approve. I'm just saying.
Oh,
It-
sure.
It
That's-
threw me
approve
off.
is
I
fine.
apologize. I'm wasting time.
That's
It's
fine.
been seconded. Back to you, Member Davis.
Thank you. I think if you look in draft 1, the concern in draft 2 are the lines 117 through 130, and concerns have been brought up by Member Bogus and Lear and Carey and others. And I think if we look back at draft 1 that the committee moved forward, it still is starting to address these concerns about the risk and the educators and things, but it lists them kind of in a prioritized order. Now, it has a may instead of a shall, but I think that this is probably a better place to be in for now, and then the committee can go through and decide how they want that language of prioritization to look like. But I think for now, draft 1 would be the better draft to work from as the committee is going to move forward.
Okay. So the motion before us is to approve draft 1. Seeing no additional lights, Vice Chair Bollinger is going to take up voting for us. So not voting for it. That sounded wrong, but Vice Chair Bollinger, please. Yes.
Okay, Member Bogus.
And can we, do we need to repeat it? If we're not going on mics, will you just repeat their vote? So we don't have to turn everybody's mic on?
Oh,
Just
sure,
say
sure.
Bogus,
Okay,
yes.
yep. Member Bogus is a no.
It's a yes.
Oh,
She's a
sorry,
yes.
is a yes. Member Bogus is a yes. Member Booth,
Yes.
Member Britton, Member Britton,
Yes. Sorry. Yes.
Member Davis,
Can you hear
Yes.
me?
Member Earl. Yes. Member Earl is a yes. Member Green,
Yes.
Member Hall. Member Hall is absent. Member Kelly.
Yes.
Member Kelly is a yes. Member Carey.
Yes.
Member Carey is a yes. Member Lear.
Yes.
Member Lear is a yes. Member Longacre. Yes. Member Longacre is a yes. Member Reel. Yes. Member Reel is a yes. I am also a yes. And Member or Vice Chair Wood. Yes. Vice Chair Wood is a yes. And Chair Hymas.
Yes.
Chair Hymas is a yes. So that passes unanimously, 14 in favor and 1 absent.
Okay. Chair Carey.
Chair, just a point of clarification. The UPAC rules, now that these amendments or drafts have passed, is there any further action that this board needs to take regarding the extension of our UPAC rules and their 5-year review, or does our passage of those rules satisfy that requirement?
Director Rasmussen.
By board policy, we have authority to file a continuation with the amendments, and that's what we'll direct staff to do.
Thank you, Chair. The next matter before the board, going back to the agenda, is item 10.5, R277-301, educator licensing. And the motion before the board is that the board,
Clarity.
oh, thank you.
Yeah, 303. Chair, does that sound?
Yep, 10.6, thank you.
Okay.
The item is 10.6, R277-303, educator preparation programs. And the motion for the board is that the board approve R277-303, educator preparation programs, draft 1, on second and final reading.
Thank you. The motion has been stated. Member Earl. Member Bogus.
Just through the chair, I'm wondering why we are striking lines 145 through 146.
Does that come to the committee chair, or do we have,
It goes to wherever you would like to direct it, Chair.
is there, I don't recall the committee discussion regarding that, or where that came
I
from.
think it was recommended by staff, the way the draft reads.
Yeah, Director Rasmussen. Ben, please.
I have, Malia left me a note because she couldn't be here. Oh, Malia's here. Excuse me. Can we have Dr. Height answer that?
Did you hear the please, Dr. Hyde, please, did you hear the question? Is that,
Would you like me to
please, Member
restate?
Bogus?
Dr. Height, I'm wondering why we're striking this language here, or, and I guess can I tell you my concern? My concern is that we say they can recommend for up to 5 years, which I believe is intended to open things up for forever and a day, but I don't know that that's the intent. But the way it would read is as long as current licensing requirements have been met. So if you have a degree that's 10 years old from another state, you apply for a license, you don't meet the licensing requirements, then that's no longer accepted. Even if you've taught in another state, I see lots of crazy going on here if we don't rectify the language. So can you help me understand it?
Yes, thank you so much, Chair. Malia Hyatt, Executive Coordinator of Educator Licensing. So this section is specific to educator preparation programs that are board approved and university programs. And so if they finish a Utah university program and meet license requirements, they may be recommended. The language that is stricken is because the 5-year limitation used to be, previous to 2020, aligned with the accreditation standard that universities required. However, since 2020, all graduates have to meet current license standards in order to be recommended. So there's no limitation on when they completed their degree. As long as they meet the current competencies, they can be recommended for a license.
So just for clarity, this isn't going to cause any hubbub with the interstate compact with teachers coming from out of state and transferring their license into the state with a recommendation from their university.
No, absolutely. The Interstate Mobility Compact allows a teacher that has a standard professional license in another state to be issued a license in the state of Utah.
Okay, that satisfies my concerns, sir. Thank you.
Thank you. Member Davis.
Oh, I was trying to look up the code really quickly. Is the 75% in code, or is it is something that we added as a definition?
May I respond? Julie Clark, P through 12 English Language Arts Coordinator. So the 75% is not in code, which is why we're putting the definition into rule. What is in code is low rates. So our educator preparation programs were asking for what is low rates, and so it was shared with them when SB 127 was passed that low rates would be 75%. So we are just putting that into rules so that we can have that as a metric.
May I follow up, Chair? So if the program doesn't have higher than a 75%. The only thing that the force function is that they get additional support in helping students, correct? Or in helping instructors or what have you.
Chair, may I respond? Yes, they would fall into a system of support where we have a staff member that would support the educator prep programs in building their science of reading instruction in their educator prep programs to support them getting higher passage rates.
Okay, and just one last quick final. I have noticed that oftentimes when students are not passing the exam, it's due to language barriers. So, I just think we're going to have universities that have higher amounts of multilanguage learners that might be in this situation. And I hope we're prepared, not just with literacy strategies, but with some, multilanguage types of strategies to help.
Chair, may I respond?
Sure.
Yes. So we do have, if they do not pass the first time, there is a flex option through the Foundations of Reading assessment. And we also have micro credentials that they can do to meet those requirements as well. So we do have alternate pathways for educators to be able to meet the requirements.
That's good. They just cost money. And the first one doesn't. The first time you take the test, it doesn't cost.
Correct.
And it's hard for a lot of these students.
Member Carey?
Yeah, I appreciate this addition. One question that I have is how many of our university preparation programs consistently or regularly fail this metric if it were 75%?
It's red. Oh. Oh, red is good. I thought it was green. Green downstairs is good. Yes, I have this. Yeah, yes. So thank you for the question. And we have about half of our university programs are meeting that metric and about half are not. And we do have, looks like 1, 2, 3, 4 that are at 69%. So, and that was based off of last year's Utah Foundations of Reading assessment percentages. And so they're very close to that 75% of being able to meet that. And we also do break it out by program. So each program, so there's elementary education, special education, and early childhood education. So each of those programs need to meet that 75%. So if a university has an elementary education that is over the 75%, but say their early childhood is not, we will provide support to the early childhood educator prep programs and not necessarily the elementary because they are meeting it. So.
One follow-up, Chair. So the assistance that they get if they fall below the 75%, is that provided to the educator or to the actual system? Like, are we trying to improve the system so we're not back next year and the year after that? Or is our effort focused on this particular cohort getting them licensed?
Chair, may I respond? Yes. It is to the system. So it is the educator preparation program system. So the professors and the schools of education that we would be providing support to. We are looking to change the instruction in the system so that our educators are coming out prepared to teach our students how to learn how to read.
Those Yushi folks can be a little bossy, so
Yeah.
where you're...
Yes, they can.
Thank you, Chair.
Thank you. The motion before the board then is that the board approve R277-303 Educator Preparation Programs Draft 1 on second and final reading. Member Bogus?
I am sorry. I should have put my light on earlier. Does passage imply completion, or does it imply passing a test? Because remember, Carrie just asked a question, and then it changed my understanding of these words.
Off now. There we go. It is passage of the Utah Foundations of Reading assessment. So they, as we have teacher candidates in the education prep program, they are receiving instruction on the science of reading. And then at the during their time at the university, they will have the opportunity to take this assessment and it is based off of the passage rates of how the percentage of students that pass the foundations of reading assessment. That
Okay.
it is in code.
I
Yes.
appreciate that. It might have been a misstatement or maybe I misunderstood. Thank you.
Okay. So again, the motion before the board is that the board approve R277-303 Educator Preparation Programs Draft 1 on second and final reading. Let's vote.
Vice Chair Wood,
Brinton's a yes. Oh, sorry.
Vice Chair Wood is a yes. Member Reel? Yes. Member Reel is a yes. Member Longacre? Yes. Member Longacre is a yes. Member Lear?
Yes.
Member Lear is a yes. Member Carey? Yes. Member Carey is a yes. Member Kelly?
Yes.
Member Kelly is a yes. Member Hall? Member Hall is absent. Member Green?
Yes.
Member Earl? Yes. Member Earl is a yes. Member Davis? Member Davis is a yes. Member Britton?
Yes.
Member Booth?
Yes.
I am also a yes. And Member Bogus? No. Member Bogus is a no. And Chair Hymas?
Yes.
Chair Hymas, that vote passes 13 in favor, 1 opposed, and that 1 opposed is Member Bogus with Member Hall absent.
Okay, I don't know why. We're going to go back to Chair Carey. Member Davis, you have a light on. Okay, Chair Carey, go ahead.
Next item on the agenda is 10.7, R277-723 Start Smart Utah Program. And the motion before the board is that the board continue and approve R277-723 Start Smart Utah Program Draft 1 on second and final reading.
Thank you. The motion before the board is that the board continue and approve R277-723 Start Smart Utah Program Draft 1 on second and final reading. Seeing no lights, let's vote.
Member Bogus? Yes. Member Bogus is a yes. I am a yes. Member Booth?
Yes.
Member Britton?
Yes.
Member Davis? Yes. Member Davis is a yes. Member Earl? Abstain. Member Earl is abstaining. Member Green?
Yes.
Member Hall? Member Hall is absent. Member Kelly?
Yes.
Member Kelly is a yes. Member Carey? Yes. Member Carey is a yes. Member Lear?
Yes.
Member Lear is a yes. Member Longacre? Yes. Member Longacre is a yes. Member Reel?
Yes.
Member Reel is a yes. Vice Chair Wood?
Yes.
Vice Chair Wood is a yes. And Chair Hymas?
Yes.
Vice Chair Hymas is a yes. So that passes 13 in favor, 1 abstention being Member Earl, and 1 absent being Member Hall.
Thank you, Chair Carey.
The next item is 10.9, R277-608 Emergency Safety Interventions and Prohibition of Corporal Punishment. And the motion for the board is that the board approve R277-608 Emergency Safety Interventions and Prohibition of Corporal Punishment, Draft 3.
Thank you. The motion before the board is that the board approve R277-608 Emergency Safety Interventions and Prohibition of Corporal Punishment, Draft 3. Vice Chair Wood.
I have a motion to amend. I move that the board amend draft 3, lines 215 through 217 to read as follows. A, a behavioral intervention. B, as a disciplinary practice. C, for coercion, retaliation, or humiliation. And D, due to inadequate staffing.
The motion before the board then is that the proposed motion is that the board amend draft 3, line 215 to 217 to read as follows. A, as a behavioral intervention. B, as a disciplinary practice. C, for coercion, retaliation, or humiliation. D, due to inadequate staffing or. Do we have a second? Second. Back to you, Vice Chair Wood. It's been seconded. Sorry, Vice Chair Wood. Go ahead.
Well, I had a concern as it came out that we were seemingly saying that this could be used other than those reasons for coercion, retaliation, or humiliation. But when we looked at code, it was just a typo. It was supposed to be two separate lines. So that this should never be used for any of those reasons.
Member Bogus?
Yes, sir. Thank you. I'm wondering why we're removing for the staff members' convenience.
Elise, is this to this question? Are you answering this question? Go ahead.
Thank you, Chair. We're not. We would just need to change the lettering. So it would be or and then E staff members.
Okay, thank you.
Okay. Seeing no other lights, let's go ahead and get ready for the vote. Member Earl, go ahead.
Can you give me just 2 minutes, maybe 30 seconds? 30 seconds? I just need to verify something, and it was
Okay.
taking me a minute to get to it. Because I don't want you to do that and then me making amendments.
Go ahead and reset your light for us, and then Member Carey.
I have a 30-second question. So on line 233, the paragraph says if a student is placed, I guess, in seclusion, the school or the school employee shall provide notice immediately and not to exceed 15 minutes after use. My concern is we use the word shall provide notice. Does that mean that what if the parent cannot be contacted? It doesn't say attempt to notice, it says provide notice. So I just want to make sure that we're not setting up the LEA to do something that even with every effort, they just can't do. If a member of staff could address that, that would be fantastic. Thank you.
Thank you.
Christiane Lewis, Student Services Coordinator. Thank you for that question. The way that we're interpreting this is it's really that attempt to notify the parents. There's not a requirement that we actually reach them because that would be very difficult, as you've pointed out. So we would be open if there's a wording change there, but the way that we're interpreting that is there's an attempt to reach them, email, phone, text, through whatever means we need to use.
Yeah, go ahead.
I mean, I would just ask, like, if we put the employee shall attempt to provide notice.
Member Carey, can I speak to this for
Please.
just a second? And
Yeah.
I recognize that this is out of order, but we were trying to buy some time here. But when I read this, and tell me if I'm wrong, or when it says if a student is placed in seclusion, the school or the school employee shall provide notice immediately, that means an attempt would be I called and nobody answered. If I provide notice, I take a second and leave a voicemail. That's providing notice. And so, an attempt is I call 3 times, nobody answered, they still don't know. That's how I interpret this, and I would hope that other LEAs would as well. Maybe if I call and the voice box is full or voicemail box is full, then I send an email. But some sort of notice, we can't control when the parent gets it, but we can, as LEAs, control the notice going out. I don't know if that answer. Anyway, that's again interpretation, but please. Yeah, we can.
I appreciate that clarification. Thank you. That I think you worded it better than I did, and that's our interpretation as well. So thank you.
Thank you. AAG Beal, any direction?
Yeah, I'm sorry. Elise and I, Director Newey and I were just looking at that. What about the inclusion of the word reasonable?
We'll let that sit on the minds of individuals. Let's go back to the motion at hand, if we could. And let's see if we can get that back. No, there's Vice Chair Wood has a motion before us that the board amend draft 3, line 215 to 218 to read as follows. A, as a behavioral intervention. B, as a disciplinary practice. C, for coercion, retaliation, or humiliation. D, due to inadequate staffing, or E, for the staff member's convenience. Member Lear. Okay. Let's vote on this amendment. Go ahead. Vice Chair Bollinger, please.
Member Bogus. Member Bogus is a yes. Member Booth.
Yes.
Member Britton.
Yes.
Member Davis. Member Davis is a yes. Member Earl. Member Green.
Yes.
Member Green is a yes. Member Hall. Member Hall is absent. Member Kelly.
Yes.
Member Kelly is a yes. Member Carey. Yes. Member Carey is a yes. Member Lear. Yes. Member Lear is a yes. Member Longacre. Yes. Member Longacre is a yes. Member Reel. Yes. Member Reel is a yes. Vice Chair Wood. Yes. Vice Chair Wood is a yes. I am also a yes. Member Earl. Yes. Member Earl is a yes, and Chair Hymas.
Yes.
Chair Hymas is a yes, so that passes unanimously with Member Hall absent.
Thank you. So the motion before us then is that the board approve R277-608 Emergency Safety Interventions and Prohibition of Corporal Punishment Draft 3 as amended. Vice Chair Bollinger.
Thank you, Chair. I do have an amendment that I would like to, or a motion that I would like to make on an amendment. And that is that the board amend draft 3, line 165 to read, key identified school employees shall receive comprehensive ESI training that is research and evidence-based in addition to the foundational behavior support training. And I'll speak to the motion with a second.
Okay, it's been stated and seconded. Go ahead, Vice Chair Bollinger.
Thank you, Chair. And this is in collaboration with some of our staff that we want to make sure that LEAs know that they don't have to come up with their own training and that they can use training that is already evidence-based and research-based that's already ready to go. ESI training is very specific. We want to make sure our employees are trained appropriately in using this. Thank you.
Okay, so the addition to line 165 and 166, you can see in blue there, and that is research and evidence-based in addition to the foundational behavior support training. So we've got Member Earl, then Member Carey.
I think, sorry, this is just, I'm hoping that the research we're using is, there's just a lot of research out there that is just not sound research. I don't know that there's something more we can put in there that says sound research. That sounds crazy, but there is a lot of research out there that's perpetuating information that's inaccurate. So I don't know how we do that. I guess we just are hoping our staff just really are thorough in making sure that it's not just perpetuating an ideological kind of a thing. And maybe I'm just voicing this more than anything, because there is significant research out there right now that's showing that some of our research is not really sound. And this is in many areas. It's medical as well as what used to be a very respectable field. We've found that we're seeing some holes in there, and then we're perpetuating the narrative. And AI is not helping with that because it is actually facilitating some of this inaccuracies. But I know our staff are very thoughtful and thorough on things. I just want us to be, and I'm just maybe voicing this more than anything, that we're really cautious about making sure it's not just a perpetuation. So thank you.
Member Carey.
Yeah, question for the maker of the motion. Through the chair, what is the difference between ESI training and comprehensive ESI training?
Yeah. Vice Chair Ballinger.
Thank you, Chair. If I can direct that to staff to help us answer that question.
Thank you, Christiane Lewis, Student Services Coordinator. So there are two types of ESI trainings. There's the foundational, and then there is the comprehensive. So in this section that you're referring to, it is talking about the comprehensive ESI training, which is the physical holds, exclusive. The foundational behavior training covers de-escalation, covers behavior interventions, and this comprehensive covers everything related to holds and ESIs, if that helps clarify.
Follow up.
Thank you, Chair. And if I may follow up, I do know that being in schools and having been trained myself, it is very important for our employees that are trained to know how to do this appropriately to decrease the risk of being injured themselves as well as students being injured. Thank you.
I recognize Vice Chair Ballinger had a follow up. That was, remember Carrie's question. Does that answer your question? Remember Carrie?
Yeah.
Okay, thank you. Next, we have Member Davis. Member Lear.
I appreciate Member Earl's concerns and her comment, but I also feel like because of the many, all of the information that's out there, I think the board needs to look to the information that we feel like we can trust the most. We have a staff hired by a superintendent that we selected that provide, and we can find the background of our staff members. So if this is something they support and recommend, that is persuasive to me. Also, Member Vice Chair Ballinger works in this area, has a background in special education and at-risk youth, and I think that's another source we can look for. So I would prefer looking to those sources for support and believing those sources than sometimes other sources that are less certain and less dependable.
Okay, so the motion before the board is that the board amend draft 3, line 233 by adding, or I'm sorry, that the board amend draft 3, line 165 to read, key identified school employees shall receive comprehensive ESI training, and then here's the new language, that is research and evidence-based, and then back to original, in addition to the foundational behavior support training. Let's go ahead and vote.
Vice Chair Wood? Vice Chair Wood is a yes. Member Reel? Yes. Member Reel is a yes. Member Longacre? Member Longacre is a yes. Member Lear?
Yes.
Member Lear is a yes. Member Carey?
Yes.
Member Carey is a yes. Member Kelly?
Yes.
Member Kelly is a yes. Member Hall? Looks like Member Hall is still absent. Member Green?
No.
Member Earl?
Yes.
Member Earl is a yes. Member Davis?
Yes.
Member Davis is a yes. Member Britton?
Yes.
Member Booth?
Yes.
Member Bogus?
No.
Member Bogus is a no. I am a yes. And Chair Hymas?
Yes.
Chair Hymas is a yes. So that passes with a vote of 12, with 12 in favor, 2 opposed, those being Member Green, Member Bogus, with Member Hall absent.
Member Longacre.
Yeah, in lines 165, it says key identified school employees. What constitutes a key identified school employee?
That is up to the LEAs to decide who those key employees are. We have left that up to LEAs because every classroom, every school is structured a little bit differently, so they would be able to identify the people who are most important to have that training.
Member Carey.
Thank you, Chair. I have just a question, and then I'd like to make a motion on that line 233 with the notice. My question is, I've seen in this latest draft that we have removed, I'm looking at line 181, but it occurs in other places as well. We've replaced significant threat with immediate danger. And I think by doing that, we've lowered the standard of when physical restraint and seclusionary timeout may be used. And it's clear in the rule that physical restraint and seclusionary timeout can only be used when no other safe or effective intervention is available. So, one, and I don't know who to direct this to, maybe staff, maybe council, but did we reduce the standard by saying it no longer has to be a significant threat to self or others, just an immediate danger? Did we make it easier to place students into seclusionary timeout or to use physical restraint?
I've got light on. Here you go. Did you select that, Elise?
Yes.
Go ahead, please.
Thank you so much. So if you go up to the definitions in 52, this was an ongoing conversation, if you recall, during the committee meetings. There is some different language that's used throughout code and throughout our rules, and we wanted to be consistent. And so in the definition, immediate danger can also mean immediate and significant threat, and both of those mean the same thing, that it is both the immediate risk of physical violence or other behaviors which are likely to cause imminent risk or of substantial or serious bodily injury. So the standard is the same. It's just the term that we're using to make things clear.
Thank you.
Okay, well, perfect. And you have a motion.
A motion.
Go
If
ahead.
we go back to line 233, and I'd like AAG Beal to weigh in on this, but after discussions, I would like to make the motion that it read on line 233, employee shall attempt notification instead of provide notice.
So we would strike provide notice and replace with attempt notification. Is that correct?
Yes.
Do we have a second? We have a second. Back to you, Member Carey.
And thank you, Chair. And through the Chair, with that change, AAG Beal, does it comport with code? And do you think it clarifies the intent of the rule?
AAG Beal, if you're willing.
Yes. After looking at it, we do feel like it complies with code, and I do think the reality of it makes it a little bit more, provides clarification for those situations where actual notification might not be possible, right? A parent who doesn't have a voicemail that's set up, something like that. So I think it complies with code and the intent behind it.
Thank you. Member Davis.
I just remember when we struggled with this years ago. Is the 15 minutes, is the 15 minutes being added in to this draft? Is that after or before?
Before the notice?
The notice is pertinent to the 15 minutes, and it says 15 minutes after use. Is that after you're done with a hold? Is that after you put a child in a seclusionary timeout? Do you go back and call from 15 minutes, or is it when the child comes out of the timeout within 15 minutes you have to let the parent know what happened?
Please.
Thank you. That is after the emergency safety intervention has ended. So it's ended and they have 15 minutes to provide that notification.
So while the child is in the seclusionary setting, your eyes are still on the child, and you're after it's all over. Man, I've been in situations like this, and it's tough, and there are no good answers on the timelines, because you need to have 4 more hands to do what you need to do, and 2 more brains. But thank you.
Yeah, your people are kind of busy, right? Yeah. Member Bogus.
So I'm going to respectfully disagree with Member Carey's amendment. I don't think it's appropriate. We have ways in our systems wherein parents can be communicated with in 3 different ways all at once. To replace that language with attempt, I what is it? I tried to make a phone call when I could have got on the system and sent them a text message, an email, and a voicemail all in one, communicated and translated into their language of preference. I think notice is better. I think it encompasses the communication protocols and systems that we have in place in our schools. And I don't think it's a far stretch to provide notice. I don't think it's a far stretch. I think it's attainable, easily executed, and I think we should do that so that when these students are in these places, that parents have notification, and how they choose to do that is fine. But I don't think attempt is a good word here. Thank you.
So the motion before the board is that the board amend draft 3, line 233 by striking provide notice and replace with shall attempt notification. Let's vote.
Member Bogus.
No.
Member Bogus is a no. Member Booth.
Yes.
Member Britton.
No.
Member Davis. Member Davis is a yes. Member Earl. Member Earl is a yes. Member Green.
No.
Member Hall. Member Hall is still absent. Member Kelly.
Yes.
Member Kelly is a yes. Member Carey. Yes. Member Carey is a yes. Member Lear. Member Longacre. Yes. Member Longacre is a yes. Member Reel. Yes. Member Reel is a yes. Vice Chair Wood. No. Vice Chair Wood is a no. I am a yes. Member Lear. Yes. Member Lear is a yes. Chair Hymas.
No.
Member or Chair Hymas is a no. That ends the vote with 9 in favor, 5 against. No votes being Member Bogus, Member Britton, Member Green, Chair Hymas, and Vice Chair Wood, and that motion carries.
Okay, so the motion before the board then is back to the main motion as amended, and that is that the board approve R277-608 emergency safety interventions and prohibition of corporal punishment, draft 3 as amended. Let's vote.
Member Bogus, I guess we'll start there. Member Bogus is a no. Member Booth.
Yes.
Member Britton.
Yes.
Member Davis. Yes. Member Davis is a yes. Member Earl. Yes. Member Earl is a yes. Member Green.
No.
Member Hall. Member Hall is still absent. Member Kelly.
We come back.
Sure. Member Carey. Yes. Member Carey is a yes. Member Lear. Yes. Member Lear is a yes. Member Longacre. Member Longacre is a no. Member Reel. No. Member Reel is a yes. Vice Chair Wood. Yes. Vice Chair Wood is a yes. Member Kelly.
I stepped out. I want to make sure that I know what I'm voting for. Is it Member Wood's motion?
We're voting for the overall, the main motion that came out of, yes. Okay, Member Kelly is a yes. I am a yes. And Chair Hymas?
Yes.
Chair Hymas is a yes. So that motion passes with, let's see, 11 in favor, 3 against. The no votes being Member Bogus, Member Green, and Member Longacre, with Member Hall absent.
Chair Carey.
Chair, just one other matter, 10.10, amendment to board bylaw, Article 4, and that matter is slated to come before the full board at our next board meeting.
Okay. And with that, I believe that concludes your report for law and licensing. Okay.